Alright, so now we're going to talk about Bethel v. Fraser, which is the Bethel School District versus Matthew Fraser. Bethel School District is up in Washington State. This took place in 1986. So we're going to focus on the same questions as the last video with Tinker versus Des Moines. Is free speech different for public school students than for the general public? Explain your answer. Do school officials have a right or ethical obligation to restrict First Amendment rights for students? Again, make sure to explain your response. And how have courts shaped the issue of student speech over time? Consider changes in society as you discuss different court cases. So make sure you use multiple cases when you answer this question. After this video, you'll be able to do that because we'll have covered at least 2 cases from Tinker versus Des Moines to Bethel v. Fraser. All right. So what happened? So what happened is there was a student named Matthew Fraser at the Bethel High School in Washington. Well, he was trying to promote a friend of his to vice president of some sort of, student council kind of thing. All right. During the speech, which took place in an auditorium, he used very vulgar, graphic sexual metaphors in his speech. During the speech, this took place in front of about 600 students in the auditorium. And before the speech, Matthew had actually discussed this speech with several teachers. The teachers told him that it was inappropriate and he probably shouldn't do it, otherwise he might get in trouble. What do you know? He got in trouble. He did it anyway. He was suspended for 3 days, and the kicker here is he was also prevented from speaking at his graduation. See, Fraser was actually a very good student, very good grades, very popular, and he had already planned on speaking at graduation. So after this took place and he was not allowed to speak at graduation, that was one of the reasons why the parents decided to fight this. So after being suspended for 3 days, he actually came back after 2 days of suspension. The parents, I'm getting ahead of myself. Let's go back to the next slide. What happened? Okay, so Matthew's father sued the school district, stating that his son's First Amendment rights were violated because they didn't let him speak at graduation. He was suspended from school, and because he wasn't allowed to speak at graduation, they also claimed that his 14th Amendment was violated, the due process clause. So that's something else all on its own. But we'll stick mostly with the First Amendment because that's what we're really covering here, freedom of speech. The district court actually awarded the student's family monetary compensation. Now, they didn't receive much. Most of what they received was actually spent on legal fees. They received like $200 and something for the 2 days of school that Matthew missed, but around $10,000 or so for court fees, attorney fees, things like that. So they didn't make out. They didn't get a whole bunch of money, but the school district was out quite a bit of money, having to pay for the legal fees for Matthew Fraser's father and their family. So the school district appealed the decision of the district court, and it went to the courts of appeal. The courts of appeal affirmed the ruling of the district court. So therefore, it was appealed again and went to, you guessed it, the Supreme Court. So, what is the issue here? Does the school district have the authority to discipline a student for lewd speech at an assembly? Does this violate the student's First Amendment right? And we'll see. The majority opinion, which was written by Chief Justice Berger, this came at a 7-2 decision. He stated that there's a difference between political speech, which is what happened in the Tinker versus Des Moines case, and lewd sexual speech that took place at Bethel High School. There's a difference. The other one, the speech that was made at the assembly was not really necessary. It didn't have a purpose or an end goal. It was just a student trying to be funny and get a laugh out of the student body. Where the other one was actually protesting a war. Now, he also went on to say that Lou's speech was inconsistent with the fundamental values of public school education. The concurring opinion, which was written by Justice Brennan, uh, he went on to say that having read the full text of the speech, I find it difficult to believe that this is the same speech the court describes. And he's referring to the district court and the courts of appeals. He's really finding it hard to believe that after reading the actual speech that the student, said at the assembly, it's hard to believe that they didn't side with the school district. The student's speech went on to say, I know a man who is firm. He's firm in his pants. He's firm in his shirt. His character is firm. But most of all, his belief in you, the students of Bethel, is firm. Jeff Kuhlman is a man who takes his point and pounds it. Okay, I'm going to stop right there. I don't need to read the rest of this, but if you look in the description, I will post the full text of the speech if you'd like to read the rest of it. It does get pretty vulgar. Apparently, during the assembly, there were lots of students in the stands making all kinds of physical gestures that went along with what he was saying. It was very, very clear what he was talking about. So that is why he got in trouble. All right, now here's the dissenting opinion. Justice Marshall dissented, saying that there was a lack of evidence that the act actually was a disruption to the educational process. So therefore, the lower court ruling should stay. He's saying there wasn't enough evidence to overturn a previous decision from a previous court. Now, Justice Stevens felt the same way, but he also wanted to add that, he remembered a line from a movie where the line reads, "Frankly, my dear, I don't give a damn." It came from a 1939 movie called Gone with the Wind. You've probably heard of it before. At the time, that was pretty, unacceptable language. To use the word damn in a movie, that was unheard of in 1939. Nowadays, that's nothing. So that's something to consider when we discuss what is appropriate for school and what is not. Should justices that are 3 generations off be deciding what is appropriate? That's kind of the point Justice Stevens was making. Though the real reason that he dissented was simply because the same reason as Marshall. There just wasn't enough evidence to overturn a previous decision. So here's a few things to think about. How is this case different from Tinker? Okay, in the majority opinion, it was basically stated that Tinker was about a political cause, an actual war that was going on. Fraser was just trying to be funny. But how was it different in the eyes of the justices? Did the school violate Fraser's First Amendment right? Do you think so? Explain. How lewd does speech have to be for the school to step in? This kind of leads us to the last thing to think about. Think about what Justice Stevens said. Who's to decide what's lewd? Should we judge what's lewd based on what our parents thought they were, what our grandparents thought lewd speech was? Should we base it off of today's society? Should that definition of lewd speech change as society changes? That's something to consider. So again, let's go back to the focus question here. Is free speech different for public school students than for the general public? Do school officials have the right or ethical obligation to restrict the speech? And how have these courts shaped the issue of speech or student speech over time? Okay, we can answer that question now, so think about it. You can also wait until the next couple videos. You can watch those as well. That way you have a little bit more information to go off of before you answer that last question. So that'll be it, and I hope this was helpful.